and welcome to Understanding Legal Issues in Banking, Credit and Debt. My name is Catherine Bowden. I'm the Community Legal Education Officer here at Legal Aid, and sitting next to me is Paul Holmes. Paul is a senior lawyer in the Civil Justice Services team, also at Legal Aid Queensland. I'm just going to run over a few housekeeping slides and then I'll pass you over to Paul to get the webinar started. Okay, so just for your information, the webinar is for community legal education purposes only. And I'd just like to pay my respects to elders past and present and acknowledge the traditional owners of the land on which we meet today. Now, the webinar is being recorded and it will be published on Legal Aid Queensland's website and on our YouTube channel, so you can find that link through our website. If you are having any technical issues, the number to call is 1800 136 402. If you'd like to go ahead and download the handout, so just in the toolbar you can expand the handouts box and you'll see the PowerPoint slides in there, and we've also got a handout for today as well. If you do have any questions, you are welcome to type them in as we go today. We'll try to get to them as we go, but any we can't get to we'll save for the end and we'll call for more questions again then. So we should have about a half an hour presentation today and then the rest of the time for Q&A. All right, I'm going to run a quick poll. So we're just interested to know what area you work in. We're wondering what percentage of you are from Southeast Queensland, Far North Queensland, regional and outside of Queensland. Looks like we've got actually quite a few of you from outside of Queensland and Southeast Queensland today. I'm just going to keep that going for a few more seconds as they come through. Okay, we'll close it off now. I'll share the results with you just if you're interested to see who the audience is today. So not all of the legislation will be relevant to everyone outside of Queensland, but Paul will be able to let you know what's Commonwealth and what's state law today. All right, I'm going to pass you over to Paul to go through the outline and present today.
Thank you, Catherine. All right, good morning, everybody. What I wanted to do just at the beginning today is just make clear that the thought behind a presentation like this is looking over the last sort of 6 months, what are the main issues we've received questions about from the consumers we assist and from financial counsellors. And then secondly, what we wanted to discuss was the type of issues we think are going to become more and more problematic for the type of consumers that we assist in the coming 6 to 12 months. So with that in mind, the outline will give you an idea of the sorts of issues I'm planning to talk about today. And like Catherine said, if there's questions that pop up along the way, I'm more than happy for you to put them in and I can try and answer them as we go, but more than happy to answer those questions at the end. Or if people want to contact us after the event, if questions pop up at that stage, also happy to answer questions after the event if you want to send them through to our community education email.
Yeah, and the best email for that will be if you've got the community education email on hand, you're welcome to use that one, and you're also welcome to use our webinars email, webinars@legalaid.qld.gov.au, and we have seen a few questions where the handouts links are broken for a few of you, so if you're experiencing trouble, don't worry, we'll be sending it around to everyone afterwards as well.
Okay, and I'm just also seeing there's some sound issues for people. That's a question for the technical help number that we gave you at the beginning.
Yeah, so again, that's 1800 136 402.
All right, so moving to the first type of issues. What I wanted to start with is we see a lot of clients still who ask questions like, can I go to jail if I don't pay my civil debts? What can they take from me? Can they take my cat? Can they take my bed? Can they take the kids' toys? And the answer to that, apart from child support and government debts, it's really clear. You can't go to jail for those civil debts. It's also really clear in Queensland that they can't take your basic household goods because they're protected in the same way that those goods are protected if your client was to go bankrupt. This is one of those slight issues which there may be differences between states, because this is an issue of what's enforceable in your state courts. So if people have a question that they aren't in Queensland about this issue, I'm happy to put you in touch with the relevant services in your state so that they can tell you about those issues. Third issue, and the reason I put up these questions is these are actual questions we've received from clients that they've been suggested to them by debt collectors or suggested to them by organisations seeking to recover money from them. And this was probably the worst one of the year. Somebody had suggested to them again, and we get this every year, that we'll make sure you lose your kids if you don't pay this bill. Not okay by the debt collector, not okay at all. If you see clients who are in this position, please make sure you refer those organisations who've been making these comments to ASIC, because they may well be in breach of their licence if they're saying these sort of things to our clients. But it's really, really important to remember that you need to tell these clients that these things can't happen to them, because it's something we all assume is true, because you and I deal with this sort of stuff every day. But it's important to remember our clients who are in a position where they're struggling, they're not as confident as us about these sort of issues. The reassurance you can give them by just saying this basic stuff is really, really important. What can they do? They can go, if an asset is secured, they can seek to repossess that asset and sell it, and then chase the person if selling the asset doesn't pay out the full amount of the loan. And we'll come to this other issue later. What they can also do, say for a credit card, is if that credit card is owed, they can go to court, get a court judgment saying that that money is owed to them, and then seek an order to sell that client's property in order to satisfy the debt. And what that property can include is if that person owns a house, that person could potentially lose their house by virtue of not paying their credit card debt. And I think that's a really important issue that we'll discuss a bit more later on. All right, moving now to a poll. Yep. And I'll hand back to Catherine for a poll.
Thank you, Paul. All right, next poll. Have you had any clients experiencing problems with payment services like Afterpay and Zip Money? Also, we've got a pretty clear no coming through here, but we'll leave it on for a few more seconds. Okay, we'll close that off now and just share the results for your own interest as well. So we had 23% say that they have had clients experiencing these problems, and a majority of you haven't experienced this with your clients. I'll pass you back to Paul to talk about that a bit more.
All right, so the reason I wanted to talk about these new payment services is particularly when you were doing your Christmas shopping, you might have seen in all the shops payment services such as Afterpay, Zip Money, and there's a whole variety of others were being advertised as being the quick and easy way to pay for your Christmas purchases, your Christmas presents and things like that. We've also seen these services offer as ways of paying for courses for people to do and things like that. Now, the shops are marketing these as the alternative to what used to be the lay-by, where you would put goods aside and gradually pay them off, and then you'd get the goods. Under these new services, what happens is you get the goods straight away, and then you make regular payments to pay it off. My concern about these new services is, unlike credit cards, unlike loans, there is no assessment being done of whether that person can actually afford to make the repayments they're being asked to make. And my concern about that is the reason they don't have to do that is they've set themselves up so that they're not caught by the existing credit laws. And the risk that poses, I think, for our clients is by them not charging interest but instead charging fees, they're not caught by the law. Now, where this is going wrong is people who are experiencing financial hardship, no longer with these particular payments have the ability under law to ask for hardship because they're not caught by any of the usual processes. So I just wanted to put this out there and flag it with you all, because I think it's an issue that's going to continue to develop, and I think we're going to end up seeing more than just a quarter of you experiencing clients with this problem. Now the trick is, well, what do we do about it under the current law? And under the current law, although it's not caught by credit law, what we need to start looking at is what's being said about these payment services and how are those companies acting. Are the representations being made about what the product can do for a client appropriate? Do they comply with the Australian consumer law? Do we have a situation where the company, in say maybe signing a person up to 4 different Afterpay arrangements with 4 different shops, is that necessarily conscionable? So what we need to do in that process is keep an eye out for these particular issues. And I think it's important that although we can still ask for hardship, I think we need to be aware that these companies are going to be less willing than all of the other industries that we've spent a long time working with to engage with us on this at the moment. And that's because there's no legal requirement behind it. So I think what I want you to take away on this particular issue is I want you to be aware and keep a lookout for it, because these are going to be harder for you to resolve than the usual credit type arrangements. And I'd also want you to keep a record of, if you see these new products causing your clients harm, it's really important that you record that, because one of the ways we change legislation and get greater protections for the vulnerable consumers we assist is by recording the harm and being able to show the harm being caused, because that's what usually prompts legislators to impose regulation to alleviate that harm. So that's one of those ones I wasn't expecting everybody to have seen yet, but it's certainly something I'm expecting a lot more of you to see in the next 6 to 12 months. All right, the third issue I wanted to talk about is a bit of a disconnection that a lot of clients have between their rights under the Australian consumer law and their rights when it comes to the loan. And it comes out often in the issue of car loans, and it's usually second-hand cars. So what happens is a client will often obtain a car loan to buy that car, and for whatever reason, that car will have a major issue shortly after the purchase. Now, under the way the legislation is currently set up, the Australian consumer law has a lot of really good protections that protect you if a good does not perform up to the standard that you would reasonably expect it to perform. So for example, you would not expect a brand new car to have 1 or 2 major issues in the first 3 or 4 months after purchase, but it might be unreasonable for you to expect that a car with 300,000 kilometres on its odometer not to have a problem at all in the first 6 months. That's the sort of discussion we're talking about in Australian consumer law. The problem for clients is what they think is, when they experience that issue, what that automatically means is they don't have to make any repayments on the loan they might have taken to buy the car. And unfortunately, that's not the case. While we're disputing the issue with the car, they need to keep making the repayments. And the reason for that is the loan company is in no way responsible for the quality of the car. And in that respect, it's really important, I think, to continue to remind clients that what obligations they have under a loan are very rarely, if at all, going to be affected by what's happening with the good. It doesn't mean they don't have any rights about the good. It's just that they don't have those rights as against the loan company. They have them as against the person or the company who sold them the car. I'll pass back to Catherine for our next poll.
Okay, another poll. So consumers often seek legal advice saying the car breaking down means they do not have to pay the loan. Are they right? Trick question, we've just been over this.
Trick question, yes.
Okay, you're all coming in at a no. Very good.
Which is good.
Yes. I won't worry about sharing that with you. We'll move on.
Also means I'm at least explaining things at least okay, which is always a good sign at a webinar. Now, the other issue that causes clients enormous difficulties is the issue of whether a debt is statute barred or not. And I know that the limit in terms of years for a debt becoming statute barred is different in the Northern Territory, but my understanding is it's the same in all other states and territories. So just be aware of that as we're discussing this. So a debt in Queensland is statute barred if it's more than 6 years since you made a payment. However, if you agree outside of that 6-year period to make a payment, or at least agree to make a payment, then that 6-year period can start again. And what usually happens for our clients in this scenario is a debt collector or a company might bombard them with a number of phone calls. That will cause the client a lot of distress. And then there'll be a phone call saying, if you just make a payment, we'll leave you alone. And the client will often just make the payment because the stress means they need to leave the person alone. Sorry, the stress means they need the company to leave them alone. And in that scenario, we need to try and help the client to hold firm, because by agreeing to make that payment, that then gives the company another 6 years to recover. And so, of course, they're happy to leave them alone for a year or two because they've got a whole 6 years to get the money back. What my advice is always in a scenario like this, particularly if the client does not remember when they last made a payment, you should always ask for evidence. Ask for evidence of what date it was made and how the payment was made. Because I have had instances where the payments have been made in a town or from an organisation where the client has never been involved in. And that would, if you just took that information at face value, your clients might end up paying a debt that they had no legal liability to pay. The other issue I'd be aware of in this space is make sure that you're always looking at one random payment that's keeping a debt alive. Because I have had instances where companies have not been able to justify how and when that one random payment was made. And me being the skeptical person I have been since birth, I'm always questioning those sort of one-off payments just to protect our clients' interests. And I noticed there's a question about the time period in South Australia. I am confident it is the same, but I would recommend that you check with, there's a Consumer Credit Legal Service in South Australia and the Legal Services Commission in South Australia, who would both be quite happy to have a conversation about the particular facts of your client's circumstances. There's excellent lawyers at both of those services. All right. My takeaway message about statute barred is it's important to ask questions, and where possible, it's important to get that client legal advice. All right. This was the issue I flagged earlier, and the reason I wanted to flag this issue is, and just before we go there, I noticed this, I'll just go back because I think there's a really important question to cover before we go a bit further, Catherine.
Yeah, should we read the question out? So, because a lot of people might be asking the same question. So for a joint debt, if a client has not made payment by the other account, but the other account holder has, is the debt barred for a client? Okay,
so my view on that is that's an issue that's related to what's called joint and several liability. And that is, when there's a joint loan, the bank or the financial services provider can come after one of you or both of you for the full amount. So unfortunately, by one person making that payment, that's keeping the debt live as a whole. and doesn't make it statute barred for the person who hasn't made a payment, which is unfortunate. And I'll be totally honest, I have seen that scenario abused in family breakdowns and domestic violence situations, where a perpetrator is seeking to maintain their financial control, and they see the action described as a good way of doing that. So be on the lookout for that. That's a really good question. All right. Moving to the next slide. This is the issue I was flagging with you guys earlier, and I think this is a really important one. A lot of our clients, quite rightfully, focus on paying the mortgage first, because that's their way of ensuring they keep a roof over their head and protect themselves in that scenario. So in that context, I think that's probably right. But what I want to emphasize is that shouldn't come at the total expense of not paying credit cards. I understand priority, but what we've seen over the last 12 months is an increasing awareness that this is not something that's as clear-cut as clients think it is. So before we go any further,
so to a poll, and I just want to say a reminder again for you, if you're having handout issues, we'll be sending them around after the webinar, so don't worry if you can't download them. Okay, a client believes their home is in no danger from a credit card company. Are they right? Yes or no? Okay, we've just launched that now. We've got some mixed answers here. Client believes their home is in no danger from a credit card company. Are they right? Most of you have answered no. I'll pass you over to Paul. We can talk a bit more about it.
Okay, and this is, I think, is a really important part of our job, and that is there is the ability for a company who just holds a credit card debt, and it's often a debt collector, to seek to repossess a person's home. And they do it by taking that person to court and saying, you haven't paid your credit card debt, or you're in arrears on your credit card debt, or you're in default, words to that effect. If they succeed in getting a court judgment for that amount, in Queensland and in a number of the other states, one of the things they can ask the court for is an order to seize and sell property in order to satisfy the judgment debt. And one of the things that's included in the definition of property is a person's home. So if that company says, okay, I've only got credit card debt, but I'm aware the person owns a home, we reckon they've got some equity in it, they're likely to start the court action, get the judgment, and say to the court, I want the bailiff to seize and sell that house so that we can unlock the equity and have our debt paid. Now, in addition to losing the house, the downside for the client in that story is $3,000 or $4,000 credit card debts probably end up at $10,000 or more of a court judgment. But you're in effect losing your house because you don't pay a $3,000 credit card debt. It happens all the time, and it happens very regularly, and it's something I've seen on the increase in the last 12 months. So I would urge you to be on the lookout for this sort of issue. Is it legal for companies to do this? Absolutely, totally it is. So we need to be aware of that, and it means, in addition to dealing with the mortgage, we need to get, I would argue, those hardship arrangements in place on the credit cards in order to ensure that our client's home is protected. So I know that's of concern. The other variation I've seen companies do in this story is I've seen them bankrupt people. So they'll get the court judgment, and rather than ask for an order to seize and sell the property, they'll bankrupt them and have a trustee appointed. And then the trustee will make a decision about whether it's in the circumstances worth selling that person's home. In addition to the home being at risk in the bankruptcy scenario, there's of course the other issues, which are that you've got the bankruptcy on your credit report for 5 years, which makes lending and refinancing debt and mortgages very difficult. You're on a register for life. It lasts for about 3 years and 1 day. And anecdotally, what we see is people find it harder to rent. Now, the one thing I would emphasise here is you can go bankrupt on a debt which initially might have been $3,000, because what happens is by the time you get a court judgment, the debt is no longer $3,000 because you add interest, you add court fees, and you add legal fees, which the company will get as part of the judgment. So that ends up where that's how a $3,000 initial debt can end up over $5,000 and still lead to that person being bankrupted. So that's a really important issue for me, because it's something I saw a lot of, and particularly the second half of 2017. And I would see no reason why the companies who were doing it are likely to change a practice that they would see as being really important to them and being successful too. So moving to the next issue. And this is one I always raise. But what I wanted to say, and this is my experience of this in the last 12 months with a lot of financial services providers, has actually been quite positive. So I know I've spoken to some of you who are online before about things like there's an Australian Bankers Association guideline on dealing with joint debts in domestic violence. And there's also a financial ombudsman position on the same issue. And there's also a credit and investment ombudsman position on how joint debts can be dealt with in the context of family and domestic violence. And the reason this is important is, at law, when you have a joint debt, as I mentioned earlier, people are jointly and severally liable, which means even if a person is paying what they view as their half of the loan, if the other partner or ex-partner is not, that doesn't affect the bank. And the bank can still come after the person paying their half for the full amount of the loan. So that's really, really important to remember. But my experience, and we'll do a poll to see whether my experience reflects what you guys have been seeing, is that my experience in the last 12 months is when we're starting to raise these issues, particularly when it's related to domestic and family violence, what we're seeing is banks and debt collectors and other financial services providers are being more willing to talk about appropriate resolutions for the client. So before I talk about what they've been in the last 12 months, I'll pass you back to Catherine to run this next poll.
Okay, so just rate your own experience here. Can you please rate your experience with the way financial institutions treat clients who have been the victim of domestic and family violence? Have you had a fairly positive experience, just an average experience, or quite a negative experience? So this is your experience about how financial institutions treat clients who've been the victim of domestic and family violence. We can actually see a lot of you have had a positive experience. We might close that off now and share the results with you. You might be interested to see the audience feedback here. So most of you have had a positive experience. Second to that, there's been no change, and there's been a few of you with a negative experience as well.
And I think that's probably reflective of some companies are dealing with this issue very, very well, and some companies probably still aren't up to speed yet with what's an appropriate response.
Yeah.
And because I've certainly dealt with a number of banks, and particularly the bigger banks. I'm aware there's a couple of bigger banks that actually now have specific programs whereby they will assist customers who are in family and domestic violence with non-banking help to help them out of violent relationships. So that sort of stuff is reactions I don't think 12 or 18 months ago we would have ever dreamed. I've had a number of clients where companies have been willing to either waive the debts that victims of family and domestic violence have had, or at the very least agree to only pursue the perpetrator where there's enough evidence of that. But I think the one area I think I've probably struggled with most is most of my positive experience has been where there's been a joint debt. I think companies are probably still struggling a bit more with how best to respond to circumstances where the perpetrator forced the victim to take out a loan just in the victim's name. Because in that scenario, I think they're finding it's a lot harder to work out how to recover that money or to go after that money from a perpetrator where there's no legal tie to the debt or to the loan.
We've had a few comments come in, Paul. So some people have been saying their experience obviously depends on which bank it is,
Yeah.
which is what you mentioned, and a few people have said that they've had good experiences with the big four banks and not so good experiences with the smaller banks. And we've got another question here, which I might just quickly go over. So someone's wondering what your view would be about a family law property settlement such that one party indemnifies the other in relation to a joint debt.
Yeah.
But then the indemnifying party does not pay the debt.
Yeah.
So can the indemnified party rely upon the family court order in defence to a proceeding in debt recovery in the magistrate's court?
Yeah, okay. And this does happen a bit where you have a family court order that deals specifically with who has to pay the debt and how they have to pay it.
Mm-hmm.
And then that doesn't get followed through with, or it doesn't get met. Problem for us in the debt recovery sense is those family law court proceedings are not binding on the creditor unless you have paid for the creditor to be joined to the family court proceedings. So where that doesn't happen, the only way of dealing with that is to go back to the family court, and not being a family lawyer, I can't comment on what the process is, but you would have to seek to enforce that order in family court, but that won't put on hold in any way any debt recovery proceedings launched by the bank or launched by a financial service provider, which I know seems unfair, but where they're not a party to the proceeding, I think it's a little unfair to expect them to have to abide by an order that they weren't a party to.
Yeah. Okay.
All right. So the other thing I'd just quickly say before moving on about the DV guidelines and that experience is remember also that the two ombudsmen have really clear policies on how they expect organisations to respond in family and domestic violence situations. So it's always worth, if you're not happy with the response, having a read of those guidelines and just making sure your circumstances don't fit within it. Because if they fit within it, you might well get a better result by going to the ombudsman and raising the issues there. Mm-hmm. That's the other really important issue that everybody needs to remember. Just because the company said no, that's often not the end of the story.
Yep.
And it's the same concept, and we've had another question around family law court proceedings. Mm-hmm. I think it's fair for me to say generally, if you've got a family court order of any description that's dealing with the property or the debt and it's not met, the bank is not going to be bound by that unless they've been joined to the family court proceedings. And if those orders haven't been complied with, it's back to the family court you need to go. All right.
Okay. I
might move to our next issue. And that's another poll, which is around credit listings and defaults, which is another problem we see a lot of.
All right, when can a credit listing or default be removed from your credit card report? Can it be removed when the debt was never owed by you? When the wrong amount is listed? When the requirements to give a person an opportunity to remedy a default are not complied with? Or all of the above? So I'll give you a minute to read that one. We've got quite a lot of you between two answers. So leave it on for another 20 seconds and let those come through. All right, I might close it there. I'll share the results with you and I'll let Paul have a chat to you about this. So the majority of you believe that it's all of the above. Then we had quite a few of you who believe that the credit listing or default can be removed from the credit report when the debt was never owed by you. And a few of you who believe that it's only when the requirements to give a person an opportunity to remedy a default are not complied with.
Yeah, and so I was expecting most people to be on top of this. It is all of the above, in my view. But the reason I raise it as an issue is recognising that the default can be removed is probably the easiest bit in this process. My experience is it's actually quite hard once you've recognised this problem to actually help the client get the default removed. I know my experience in dealing with both the companies who have listed the default and the credit reporting agencies is their processes for allowing you to remove a default are actually quite difficult to engage with. And particularly if you're a client who's not used to this process, wading your way through the Equifax process, for example, which last time I checked still doesn't have a phone number where you can ring the company. And what that means is you have to do everything online. And if you're a client who doesn't engage with the internet or doesn't have internet access, that can make it extremely difficult for that client to get access to their rights to have this default removed. The other concern I want to raise in this space is it's not, there's a new problem clients are experiencing when it comes to credit reporting. And so there's a couple of things I'll raise. Firstly, it's important to remember and remind clients that they don't have to pay one of those paid services to negotiate with Vita and, sorry, it's now Equifax, to have their defaults removed. It's a free process. You raise it with the credit provider. If they say no, you raise it with Equifax or the relevant credit reporting agency to have it removed. The fact that the debt is now being paid is not a reason to remove the default. All that happens is it gets changed from unpaid to paid. But the bigger issue I'm starting to see is some of these credit report agencies are actually starting to list a claim that's lodged in court against a person on the person's credit report. So let me be clear about this. I'm not talking about a court judgment where the court has determined that somebody owes another person or another company money. I'm talking about where all that's happened is somebody has filed a claim in court alleging that the person owes money. Now, I think this is unfair because there's been no final decision about a person owing money, and yet the credit reporting agencies involved are drastically affecting people's credit report by putting this claim on there when it is yet to be proved. And so please be aware of that might actually be something you guys start to see as well, that's affecting people's ability to gain credit. And it's not because they actually have a court judgment, it's actually just because somebody's lodged a claim in court against them. So for example, if somebody was to take umbrage with me or decide I wasn't a good person, the mere fact of them lodging a claim in court against me, even if it's totally spurious, could potentially threaten my credit rating. And I'm not sure that's a satisfactory state of affairs, particularly for vulnerable people who are less likely to be able to adequately defend themselves in court. So that's something, in addition to the stuff you guys already know about, that I wanted to raise with you all as an issue. And it's something I think we need to try and affect change about in this space, particularly with more comprehensive credit reporting coming in, which risks, in my view, particularly the vulnerable people we help, having to pay more and being charged higher interest rates for credit on the basis of that more comprehensive reporting. All right. Now, moving to another issue which will occupy us all, I believe, in the next 12 months. and that's the issue of the Australian Financial Complaints Authority. Government in November 2017 announced that they were creating this new authority as an external dispute resolution scheme for financial services and superannuation that would replace our existing financial ombudsman, credit ombudsman services. My understanding of the legislation and where it's at is it's passed the Senate, and my understanding was it was supposed to be presented to the House of Representatives yesterday. I haven't had the time to check whether it was, but in that scenario, it seems likely that that legislation is going to get passed because it would, if it's passed the Senate, the government has the numbers in the House of Representatives. So what that means is all of us are going to have to engage with a new external dispute resolution scheme or new ombudsman scheme in the next year and helping our clients. Now, I don't see this greatly changing the effective service we've been getting from the ombudsman so far. However, inevitably when there's an entirely new organisation setting itself up, there's inevitably going to be some teething problems as they get processes going and things like that. And I'm aware there's a lot of people working behind the scenes to ensure that this is as seamless as possible. However, what I'd say to you is I think it's important for us to do our utmost to help and work with this new organisation as it's setting itself up to ensure that the service that all of us, and that includes the scheme, are trying to give our clients is as seamless as possible. And I think in that scenario, if we go into it with that mindset, that this is effectively business as usual, I think that's more likely to see this scheme up and running to its fullest potential as quickly as possible. I'm not saying don't point out things when they go wrong, because they inevitably do when new schemes set up. But what I'm saying is work with them and work with the clients to ensure that transition is as effective as possible. And let's be honest, when it has happened before, when the financial ombudsman was created, it actually merged, I think from memory, 6 different schemes, and the sky didn't fall in there. And I don't foresee the sky falling in now.
Well, we just have a question
Sure.
here. If you're able to take a quick look, someone's asking if you can confirm which body or bodies AFCA, which is the Australian Financial Complaints Authority, will replace.
Okay, so the government's been really clear it's not merging these schemes. It's a replacement for the Financial Ombudsman Service, the Credit and Investments Ombudsman, and the Superannuation Complaints Tribunal. So unlike the previous schemes which didn't look at superannuation and left ombudsman schemes and left that to the Superannuation Complaints Tribunal, the plan is that this is a one-stop shop for all of those issues.
Okay, thanks, Paul.
All right, final point before I go to questions that I'll just quickly raise. We get a lot of questions about why doesn't a body, corporate or local council give us hardship? And there's a really clear reason. They're not caught by the National Consumer Credit Act, or Protection Act, or the National Credit Code. So there's no legal basis under which we can ask them to provide with hardship. So our clients. So what that means is you get a very varied response between all of the local councils around Australia as to what they're willing to do regarding rates if a client's in hardship. Some will have policies where they don't sell somebody's house until they're 3 years behind. Others will do it much quicker. So my advice in that space is often you might need to prioritise the rates because it's a lot easier, all of the body corporate fees, because my experience is it's actually a lot easier for somebody to leave their house by not paying the local council rates or body corporate than it is for them to have their house repossessed by a bank, because the reality is there's a lot more hoops that a bank or financial services provider has to jump through before they get to that point. Less hoops for the body corporate and local council. So what I'm thinking is I might now open up to general questions.
Great.
So if there's any questions anybody's had or about stuff I haven't raised yet, by all means, raise that and we will go through those questions.
Yeah, and if there's anything you just want to confirm, feel free to ask as well. Looks like we've got a flood coming in, so we'll get straight into it, Paul. Okay. All right, so someone's interested in your thoughts about credit repair companies who charge thousands to repair credit histories consisting of one small $200 debt, for example.
Yes.
So this problem's come up quite a few times for this person.
Yeah, credit repair agencies are the only group of organisations I've ever seen where there's universal agreement between the banks, financial services providers, debt collectors, consumer advocates and financial counsellors. Nobody thinks they're a good thing. And the reason nobody thinks they're a good thing is they charge people who have no money to begin with for a service that they can get for free from a financial counsellor or by negotiating themselves, or they often to fix a credit report in circumstances where legally it can't be done. So no, I'm not a fan. Nobody I know of who's in this space on either side is a fan of them. I am aware that there have been representations made by us and industry and other consumer advocates to suggest that they should be more regulated than they currently are. And I'm not aware that that's got any significant traction with government yet, but it's certainly something I think we're all going to continue to pursue.
And just a reminder that Paul and the Consumer Protection Unit at Legal Aid can give you assistance for your clients experiencing credit and debt issues. So if you don't ask your question today or something comes up in the future that you would like help with, then please give Legal Aid Queensland a call. Okay, and just on that note, just quickly let you know where you can get help. So we've got 14 offices across Queensland. We'll send around the handout later and you'll be able to see where each office is. Otherwise, jump onto legalaidqueensland.com.au and you'll be able to have a look at our locations there as well. We'll leave these numbers on the screen. Yeah.
All right.
To jot down.
What other questions have we got coming through?
All right. So could you share how you would respond to clients who are experiencing long-term financial hardship, have already had hardship from the creditor, and think that creditors should be understanding of their situation and not pursue the debt further? So this person has just listed an example of what one of their clients have said. They've said, I've explained my circumstances to them, they should understand.
Okay.
What are your thoughts on this, Paul?
That I think is going to depend a lot on the individual clients. I have significantly more success if the client's already retired and has no assets, or is it already on a long-term settling payment such as DSP and has no assets. In those circumstances, my experience is the banks respond fairly positively to that because it's really obvious that if they pursue it in court, they're not going to get any money out of them anyway. The harder question I find, and I suspect this is where the question's headed, is where people are a bit younger. They might have been out of work for 2 or 3 years, might not be going back to work in the near future. But the potential is within 4 or 5 years, they could be back at work earning some money. And in those circumstances, it's perfectly okay, I think, for a creditor to go, look, we're going to wait and we're going to see whether your circumstances change in that period, because I think it's reasonable for them, where they've got a legal right to try and recover that money, to sit there and wait. It's difficult for our clients. And the reality is, if they get taken to court, there's not a lot they can do about that if they don't have the money to enter into a payment arrangement. I will often in that scenario say to the client, look, the worst case scenario is this, and that is they go to court, they get a judgment, and in Queensland that gives them up to another 12 years to continue to try and recover that money from you.
So is 12 years the maximum they're allowed to wait for?
No, so they get 6 years from the last payment, but once they have a court judgment in Queensland, they've got 6 years to recover on the court judgment, and they can ask the court for another 6 years, which gives them up to 12.
Okay.
So difficult circumstance, but my way of doing it is I go to, okay, what will be the worst that will happen? And funnily enough, the worst that will happen is often significantly better than the client's assuming it is.
So would you think then, Paul, that it would be better for a client to lodge a hardship application before they fall behind with the repayments of the debt?
My view is yes, absolutely. But my experience is there are some companies who claim they will not look at a hardship application until somebody is actually behind. I think that's nonsense. I think if a consumer or a client we've got is aware enough to know they're about to enter into hardship, you should be able to do that before you fall behind. And if they don't, I usually end up taking the company to the Ombudsman. I'll give them the opportunity, and if they refuse to engage, the Ombudsman's where we go.
Okay, thank you. We've got a question here about insurance companies. So if we're able to talk about that for a little bit.
Yeah.
Someone's got a situation here where they've needed to claim on what looks like their building insurance.
Yep.
And the insurance company pays the quoted amount for the building work that they were insured for.
Yep.
They pay it into their bank account, I believe it looks like, rather than letting the insurance company undertake the work through their builders. So what happens then if the actual work is performed poorly, or it costs them more than what the insurance company had quoted and paid them out for? Does the client have any rights to go back to them and request for additional funds, or could they only do that if unforeseen circumstances come up?
Okay, and this happens a bit following natural disasters, and is one of the risks in choosing to get a cash payout instead of having the insurer complete the works. And the reason it's a risk is if the insurer completes the works, they will give you a warranty that the works are up to standard, completed in time. They will often, if costs blow out, they go re-look at scope of works to ensure the repairs are done properly. If you accept a cash payout, usually in that acceptance, there's terms and conditions along the lines of, you're accepting this as a full and final settlement of my insurance claim, and that will usually prevent you going back to the insurer. And that would mean if the works aren't completed to the appropriate standard, you're probably reduced to taking that company to court, which is going to cost you a fair bit of money. But that is a risk versus a reward you take in getting a cash payout quickly out of that insurance process.
Yeah, it would be very difficult to then get more money out of the insurer.
I would always recommend somebody gets legal advice before accepting or finally resolving insurance claims in that nature.
Yeah, okay, thank you, Paul. All right, moving on to the next question. What assistance is available to people who are having difficulty dealing with a credit reporting agency other than a financial counsellor or legal aid?
Look, and this is part of the problem, the only other alternative to those paid agencies we were talking about before, who in my experience generally do a very poor job at a very expensive price.
Okay, thank you. Can we look at statute barred debt again? We've got a couple of questions here about statute barred debt. So someone would just like to clarify, if there has never been a payment made, is the debt statute barred for 6 years from the date the loan was made?
All right. Generally, there are varying views on this. And in my view, I'd want to look at the contract, but it's not necessarily the loan when the loan was made. It's when the first payment was due. Often they're two different dates.
Yeah.
And the reasonable expectation the company has is that time would start when the first payment is due. And I actually agree with that. If the first payment's not till 2 months after, I think that's when time would be ticking.
Okay. We've got another question here about statute barred debt. So, is a debt statute barred when the last payment was, for example, the 3rd of January in 2012? The claim was registered on the 12th of December in 2017, but not served until January in 2018.
I would want to see the paperwork on that one, and
you can email.
And if I would recommend that client getting legal advice before going much further on that scenario.
Yeah. Okay. If you want to email us, you can.
I am aware the person who's put that question is in Queensland. Please send that through to us.
So the email again is webinars@legalaid.qld.gov.au. All right, moving on to tax debt. So what are your thoughts, Paul, about tax debt, and what options do clients have to access support
Look,
pay for this debt?
Tax debts are something where my advice, generally speaking, is be nice to the tax office. The tax office, as a general rule, have pretty wide powers when it comes to collecting debts. Keep talking to them. If your client hasn't seen an accountant and they have complex financial matters, it's probably worth sending them to an accountant as well. But as a general rule, tax debts are very much very much in engagement with the Australian Tax Office, who have very wide powers.
Okay, thank you. So a debt collector is trying to recover money owed by individuals to government departments.
Yep. Okay. So we're talking about a situation where it's the government, usually the government, trying to recover money, and they've, I guess, contracted out that debt recovery to debt collectors. I will always ask questions of debt collectors as to whether they've bought the debt or who they're recovering the debt on behalf of, because I think that will shape my response and how I deal with the person. Because in the scenario where it's the government recovering the money, my experience is governments are much more willing to, or have much more ability to look at things to do with settling payments depending on the department. Child support, they have very wide powers for dealing with that sort of stuff. So I think the key to that discussion is to work out who's recovering and what powers they have, because that should shape the appropriate response.
I've got a question about Centrelink debts as well.
Yeah.
So what support is out there for clients with Centrelink debt?
Okay, so it depends on what it is I think the client's trying to do. If they're challenging it, I am aware there's advice services available, particularly if they've reached a stage where they're in the Administrative Appeals Tribunal and the level 1 and 2 in there. I know Legal Aid through the tribunal does run advice clinics. Those aren't booked through Legal Aid Queensland, they're booked through the tribunal, where you would get expert advice from our Centrelink lawyers about those sort of issues. And I am aware there's organisations out there like Basic Rights, and I'm pretty sure there's similar organisations in all the states and territories who would be worth contacting about those sort of issues.
Absolutely. All right. Could we go back to statutory bar debts again? So this question is about the Northern Territory and how it applies in the Northern Territory.
Yep.
Can we comment on, is this a Commonwealth?
Look, the issue there for me is where the debt was incurred. Because if the contract was formed in a particular state, my view is the rules around statute bar debts apply from that particular state. And it doesn't matter if a person moves out of that state, those rules of where the contract was formed still apply.
Yeah, okay, thank you. Someone's having a bit of trouble with collection agencies that are pursuing clients to exercise the bankruptcy option. And so this is happening for small amounts and amounts just over $5,000 as well. Have I come across?
Yeah, and the answer is they'll probably then charge them a fee and a significant fee of $1,000 or more for helping them to go bankrupt, and that's why they go through that process. Again, I'd encourage them to get legal advice before they go past that point. I realise often we all don't see these problems until the problem has well and truly passed. Yep. But even if you do, they should still get legal advice about what options they may have.
Yep, great. So yeah, it is 11 o'clock now. We'll just spend about 2 more minutes getting through the last 3 questions we have here. If you'd like to stick around, you're welcome to. If not, thank you for joining in today. Okay, so to apply for bankruptcy, someone here is just talking about how the debt would be greater than $5,000.
Yeah.
Is there an amount of debt required to get a judgment on a debt?
No, I've seen judgments for less than $100.
Okay. And what are your thoughts, Paul, on tax debt? We've been into this. Okay. So if a client has failed to complete a tax return since 2001 and has run a business during that time, they're currently unemployed and in financial hardship, can they get assistance to lodge outstanding returns outside of ATO?
Look, I'm not aware of anybody, and like nobody comes to mind, but my best suggestion there might be to contact the Small Business and Family Enterprise Ombudsman and just suss out if they're aware of anybody, because that's the organisation that does a lot of work in that space. So they might have contacts that we don't have at Legal Aid, because we don't generally do that small business assistance.
Yeah. Okay, thank you. All right. Well, that's all the questions for today. And as we've been saying, you are welcome to email us, webinars@legalaid.qld.gov.au, and we'll be able to take a look and hopefully address your questions. And when in doubt, always get legal advice. Paul's got a few takeaways for you today as well, just before we leave you.
Yeah, so I would just highlight, you'll notice, at least in Queensland, front page of the Courier Mail and a couple of regional papers in the last week have been around the payday lending and consumer lease reforms. Please be on the lookout for those. I think they're really positive. The second issue I'd reinforce is be on the lookout for those issues around payment services, because I think that is going to affect our clients quite markedly. And the third issue is around that debt collection and credit cards where a client has a house. Please be aware of those 3 issues. And please, if in doubt, ask questions.
Yeah.
Because that's the only way we get the best result for all of our clients.
Yeah. Okay. Thanks very much, Paul. That was a great presentation. Got a really nice flood of thank yous coming through the questions box. That's really nice to see that you guys are appreciating our webinars, and we really appreciate you listening in. And please fill out the feedback survey, because that is what we base our webinar topics on. We're here to be able to help you guys as you need. So make sure you fill that out and make recommendations for future topics if you'd like. All right. Thank you, everyone.